Hi everyone, good afternoon. I'm glad still so many people are in this room at the end of a long conference. In this panel we're going to discuss purpose limitation is dead, get over it. And we already give a bit away of how the panel thinks about it by continuing on the undermining of data protection law. So I can already tell you that panelists are in favor actually of the purpose limitation principle. I hope there might be people in the audience who aren't or are less so that we can have a good discussion. And also because we want to have a good discussion, I will be very strict. My role is limited. I will be very strict in managing time. So after 10 minutes of presentation, I will stand up, and then after 12 minutes, I start singing, and then they will stop talking, something like that. And that's my role for this session. I'm the chair of the session. I'm Arno Lodder. I'm of counsel at Solve Lawyers in Amsterdam. And primarily I'm a professor of internet law at the Vrije Universiteit. But for the mixture of this panel, I'm today a Solve lawyer. And I will briefly introduce all the other panelists. First, Magdalena Jozwiak. She's the moderator. She works as a researcher and lecturer at the Department of Transnational Legal Studies, Vrije Universiteit. Her focus is on the fundamental rights, EU law and information law, and in particular on the understanding of the rights to freedom of expression and privacy in the context of new technologies. Then we have Teresa Quintel. She's a PhD candidate at the University of Luxembourg and Uppsala University. She spoke yesterday, so maybe you saw her, at the EDPL Young Scholars Award. In her PhD thesis, she addresses the applicability of EU data protection law to third country nationals, with a particular focus on Directive 2016/680. That's like the GDPR 679, 680 is about police and justice, as you probably all know. And she was one of the Council of Europe experts who assist in drafting the Nigerian, so she knows a lot of things, data protection legislation. Then we have Fanny Couder. She's a legal officer at EDPS. She is a member of the team in charge of the supervision of Europol. Previously, she was a researcher at the Center of IT and IP Law at the Law Faculty of KU Leuven, where she specialized in the topic of privacy, data protection, and surveillance. Then we have Tijmen Wisman, who pulled this all together. He's the organizer of this session. He's the chair of the Platform for the Protection of Civil Rights. And he's also an assistant professor at Vrije Universiteit Amsterdam, who successfully defended last week a very interesting PhD thesis, I can say, on the right to privacy in EU policy and rulemaking concerning mandatory Internet of Things systems, smart meters and eCall. And last, but certainly not least, Judith Rauhover is a lecturer in IT law at the University of Edinburgh, an associate director of the Center for Studies of Intellectual Property and Technology Law, SCRIPT. Her research interests include commercial and fundamental rights aspects of online privacy and electronic surveillance, data protection, information security, and all areas of e-commerce and internet law and policy. I hope you enjoy this panel, and now the moderator is in charge, except that I will stand up every 10 minutes or so to indicate that time's up. And we will have discussion afterwards. Please.
Okay, well, thank you, Arno. So without further ado, I would just like to thank Tijmen for putting together this great panel. And I think it's very good that we have discussion on purpose limitation at this conference, which is much needed. So I will give a voice to our first speaker, Teresa Quintel from University of Luxembourg.
Thank you very much, and thank you for this panel. I will speak about the interoperability of EU databases, and in order to understand this complex system of interoperable databases, it is good to have some kind of an overview of those that would actually constitute this interoperable system. So currently there is the Schengen Information System that is consisting of 3 regulations which have been recently adopted. One on border control, one on the return of illegally staying third country nationals, and one on police and judicial cooperation. The visa information system, which stores information on visa applicants and for short-term visas, and now there is a proposal out that would also include long-term visa holders and residence permits. The Eurodac that stores data of asylum seekers in order to support the Dublin system. The entry-exit system that was adopted in November 2017, which will basically store all entries and exits of visa-exempted and short-term visa holders to the EU. The European Travel Information and Authorization System, which is comparable to the American ESTA, where one has to submit an online application in order to ascertain whether that person can travel to the EU. And the European Criminal Records Information System for third country nationals and stateless persons, which is in addition to the existing ECRIS system for EU nationals, but it will store data on a centralized basis. Now, the objectives of interoperability are to provide for fast, seamless, systematic and controlled access to information, and a solution to detect multiple identities, to facilitate the identity checks of third country nationals, and to streamline access by law enforcement authorities to non-law enforcement systems. So it will look like that, and it will be consisting of 4 different components: the European Search Portal, the Multiple Identity Detector, the Shared Biometric Matching Service, and the Common Identity Repository. So with these components, competent authorities will be able to simultaneously query all the underlying databases that I just mentioned, and it will detect links where there's a suspicion of identity fraud. The Common Identity Repository will be a centralized database, basically, like the Shared Biometric Matching Service and the Multiple Identity Detector, but the Common Identity Repository will store certain data of the underlying databases, both biometric data and alphanumeric data. Now, the Common Identity Repository will then create an individual file for each person stored in the systems and a reference number to which system that data belongs. Access by law enforcement authorities can be granted for the identification of third country nationals by querying their biometric data, by inserting their biometric data in the system, and then the system will answer to the query by indicating whether that person is stored in one of the underlying databases. And obviously there will also be a reference indicating this underlying database. So that would be one possibility for law enforcement to access the Common Identity Repository. The second option would be on a hit and no hit basis. Basically, the law enforcement officer would query the Common Identity Repository, would then get a hit for the systems that store the data, and a no hit of systems that don't, and could then request full access to the underlying databases, for which prior authorization would be needed. Now, what would be the consequences where these databases are being accessed for the prevention, detection, and investigation of terrorist offenses or other serious crime where law enforcement can get access? So it would have consequences or impacts on the applicable data protection regime. So either the GDPR or the directive, the law enforcement directive. And this is dependent on the purpose of the processing. So while the GDPR is applicable to administrative processing, so immigration-related processing, the law enforcement directive applies to the processing carried out by a competent authority for the prevention, investigation, detection, and prosecution of criminal offenses. So it's very important that both the material and the personal scope of this directive are satisfied, that this instrument applies. Now, what are the differences where a law enforcement authority and a police officer querying the Common Identity Repository for law enforcement purposes would process the data under the directive instead of the GDPR? So there are differences relating to the data minimization principle. While under the GDPR, personal data shall be adequate, relevant, and limited to what is necessary, under the directive, data shall be adequate, relevant, and not excessive. there's only one legal basis under the directive, which is where processing is necessary for the prevention, investigation, detection, and prosecution of crime. And that has also an impact on the subsequent processing under the directive. Because in the law enforcement context, that processing is generally compatible whenever it's carried out by a competent authority for the purposes of the directive. Now, because the directive is not directly applicable like the GDPR, it always depends on the transposition in the member states. So there's some kind of discretion how to define a competent authority, what is understood by the prevention of crime, which then could lead to less harmonization. Now, regarding the interoperability and what kind of issues or concerns it could create regarding the purpose limitation principle is, first of all, that it will create new processing operations. And there could be the question whether one could simply change, or one can simply change the legal basis of the underlying databases, because now the databases that I mentioned in the beginning were all based on a basis that is not related to law enforcement, but now they, with their new legal basis and the revision of the old databases and the establishment of new databases, there will always be the additional purpose of law enforcement access. Then another question would be whether the impact assessment for the interoperability proposals was sufficient in order to establish 3 new centralized databases that hold both biometric and identity data, like alphanumeric data. Then, of course, whether the interoperability proposals are necessary and proportionate, and whether all these data and the databases are actually needed to fulfill the purpose of the database. Because where Eurodac is a database, or was supposed to be a database solely for asylum seekers, and in order to determine the first country of entry where the asylum seeker has to seek asylum to lodge the asylum application, now the Eurodac gives law enforcement access as an additional purpose and can actually be used for different purposes than actually was supposed to. Now, again, what is the purpose of the processing is always decisive also for the applicable legal framework, as I mentioned, and whether the use of immigration databases for investigative purposes was supposed to be like that, and whether identification becoming a law enforcement purpose should be possible. I recently read a feasibility study of the Common Identity Repository in which the use of inland identification was labeled as law enforcement and security purpose. And then, of course, the purpose is decisive for whether the GDPR or the law enforcement directive will apply, and that has an impact on data subject rights, because, of course, law enforcement authorities, and that's why there's a different legal regime than the GDPR, need some flexibility to process the personal data for their investigations. So data subject rights can be restricted easier because notifying data subjects could jeopardize ongoing investigations. It also has an impact on the subsequent processing under the directive, and it risks to become a function creep. And another issue is that it's not only member state authorities that will have access to the interoperability components and now already have access to the existing databases, but there will be, of course, also EU agencies like Europol and Frontex that will have access to these databases. And they have, again, other applicable legal frameworks. Like, while on national level, the GDPR and the Law Enforcement Directive apply, on EU level, it's the Eurojust regulation and the new regulation 45/2001 that will be applicable. And for Europol, yet another legal framework, which is the Europol regulation, which then also raises concerns, for example, where the Europol regulation doesn't define biometric data as special categories of data. And I think Fanny can say more about Europol.
Okay, thank you, Teresa, so much for putting light on those complex issues of law enforcement databases. And so I'll give a voice to Fanny. Please,
Okay, good afternoon. So I want to start with a disclaimer. So what I'm going to say the next 10 minutes are my personal views. They are not the views of the EDPS. I want to make that clear. So my focus will be on Europol. I don't know if I can have my presentation already. Yeah, getting ready. In any case, before we wait for the presentation to show up, so the point I would like to make today is that we are in between two models in the way we implement purpose limitation. And this is because the social-technical reality we are regulating is changing despite the existence of purpose limitation as we understood it so far. So we're coming from an implementation of purpose limitation where the purpose of the data processing activities define the control of a database. Each database has a clearly defined purpose, and this purpose serves to define which data can be processed, how long this data can be processed, if and with whom they can be shared. And there is a clear and simple reason for it. Purpose limitation is expected to ensure foreseeability of the data processing activity for the data subject. It is a key principle ensuring data quality, and it's meant to protect from the individual from comprehensive profiling on a large scale by building unbreakable walls. But obviously, once the data is there, it is tempting, and the need to connect the dots is usually too pressing to be resisted. So there are always good reasons to do so. So the next step, what has been happening, as Teresa has shown, is to give permanent access to third parties for purposes which are totally different, incompatible, from the main purpose for which the database has been created. But at some point, this is not even sufficient anymore. And in the case of the area of freedom, security, and justice, we see that the nature of the security threat evolves, organized crime becomes polycriminal, decentralized, more technologically savvy, and then law enforcement asks to get a broader and more comprehensive access to different databases because they need to see the bigger picture. They need to identify the right targets, they need to act efficiently. And they argue that purpose limitation creates fragmentation and risk of blind spots. And here, two things happen. So, a proposal to interconnect databases set up with different and incompatible purposes to be able to trace one person through the network, and the need to foster data exchanges between EU agencies or EU agencies and member states. And if you look at the Europol regulation, Eurojust regulation, the upcoming Frontex regulation, they all establish a basis for structural data exchanges. And finally, you may end up with one unique database, or maybe not, we'll see. Maybe it will not be necessary because all databases will be so intertwined that it will not even be necessary. So the question becomes, how do you apply purpose limitation in a networked environment? Is purpose limitation dead, as the title of this panel suggests? So let me give you one example, which is for me very illustrative, which is the evolution of the Europol information system. So at the beginning, when Europol was created, was established, it was decided that the data would be stored in a separated database. You had the Europol information system and 23 analysis work files. The Europol information system served a specific purpose with a cross-check on criminal data between member states. And analysis work file where and it still is, where criminal intelligence is performed by Europol. And each of these files has an opening order which defines the purpose of the kind of criminality that is being investigated, which kind of data can be processed, and which actor can access to this database. In order to link, to do some cross-check, there was an index, what was called an index function. It it was kind of a hit-no-hit system in order to limit cases where there is a legitimate interest to do the cross-check. So this tool would not be providing any information of why the entity, so why the information was present in both systems, or who provided it, or what it was linked to. It only say, okay, there is a hit, there is a match between the two databases. In case analysts wanted to know more, they had to contact the member states. Okay, so analysts from Europol considered that this system was limiting them, too limitative in their analysis because of fragmentation imposed by purpose limitation, preventing them from connecting the dots. And it was leading to a duplication of data. So in 2013, Europol introduced the new AVF concept, or Analysis Work File concept. And what they did, they decided to merge the 23 analysis work files into two big analysis work files. One set for the purpose of fighting serious organized crime, and the other one for the purpose of fighting terrorism. Within each of these big analysis work files, they created focal points, which would be thematic, and on which they would perform strategic analysis, so analyzing trends and patterns in crime, and target groups, which are specific areas on which they perform operational analysis, which is to support criminal investigation. And each of these was regulated by a specific opening order. The big change was about the access to the data given to the analysts. So analysts under this system has by default access on a reading mode to all information contained in each analysis work file. So analysis working on one target group under the analysis work file for the fight against serious crime would have access to the information processing all other target group and focal points. If they wanted to process information, data from another target group in their own target group, they would need to demonstrate a link. But this link would be, for instance, if they want to do a cross-match, or if they have an investigative link that say that they would like to explore, they say this information might be relevant. And they would have to stay within the limits of their own opening order. For instance, if they wouldn't be allowed to process sensitive data, they could not export this sensitive data from other target groups. And in order to make the link between the two AVFs, they were still using the index function. Okay, but this was not, still at some point it was not sufficient. Why? Because analysts could not make the links easily between cases of fight against serious organized crime and fight against counterterrorism, or between the information contained in the Europol information system and the analysis work file. So, the problem was solved in the Europol regulation, which entered into force in May 2017. Analysts asked the European Commission to give up the regulation of databases and move toward a regulation of legitimate uses of the data. And that's what the legislator did. In the Commission impact assessment, you can read, for instance, that the goal of this reform is to allow Europol to define the most adequate IT environment and process data in an innovative way. This regulatory framework should ensure that Europol's analysts could link and make analysis of all relevant pieces of data. It should reduce delays in identifying trends and patterns and reduce multiple storage of data. And the ultimate goal is to establish a single data repository. And for the Commission, this did not raise any data protection issues because the other safeguards were still in place. So what happened is that the Europol regulation now does not regulate the database, so the Europol information system or analysis work file, but it contains a list of legitimate purposes for which Europol can process the data. And nothing prevents Europol to have one single data repository. There are still some limitations. The categories, well, there's still the concept of opening order for operational analysis project, which are analysis work file, new name for analysis work file, but which regulate a bit that. But still, all the data is in one, well, could be processed in one environment. And what I would like to stress is that still in the regulation, you still have recital 26, which say that purpose delimitation is a fundamental principle of personal data processing, that it contributes to transparency, legal certainty, and predictability, and is particularly of high importance in the area of law enforcement cooperation. My question is, what does it mean in this new IT environment when all the data will be stored together, where analysts have full access to all the information process? This is not in the Europol regulation. The legislation doesn't say anything on the matter. So we are left in a situation where on the one hand, the Europol regulation removes the segmentation created by purpose delimitation, and on the other hand, it restates how important purpose delimitation is. So, to conclude, what's happening is, for me, the legislator is a bit avoiding to tackle the problem. Okay, so we are listening several at the level of a database. We are now focusing on specific data processing activity throughout a network. And we say that purpose delimitation still has an important role to play. But which one? And how do we enforce purpose delimitation in that context? So it's not an easy question, but that's a question we should answer right now. We should really think about it. We cannot just have this double discourse, because we cannot just conclude that purpose delimitation as data protection principle is dead. It is an essential part of the right to data protection. It has been restated in all data protection instruments. So the challenge for us to think how we can make it work in this new political, social, and technical environment. Thank you.
Thank you, Fanny, for challenging us with those hard questions. And I give voice to Tijmen Wiesman.
Good afternoon. Sorry, too much sitting. And I saw some people that are very tired of 4 days of a conference, so I give your neck a bit of exercise. So my name is Tijmen Wiesman. I work for the VU, but I also work for the Platform for the Protection of Civil Rights. Today I'm going to tell something. I made an outline, which is very nerdy for such a short presentation. But identifying bottlenecks and contemplating their elimination. It's from the Netherlands. Purpose limitation under the Directive 95/46 in the Netherlands. Purpose limitation under the GDPR. And the Dutch framework law on data exchange. So let me start with a little story. Once I followed a course, project management. It was really bad because I never managed to finish the course. And I met there a guy, and he was a public servant. He looked very atypical. He had like a steel ring through his nose and like thick glasses, like a punk rocker. And he was working on a project for the government. And the interesting thing was that our government, by then, all public authorities still had their own logo. So also the central government had their own logo, the tax service, the social security service, everybody had their own logo. And his assignment was to make one logo for the entire government. So the tax service, the inspection for social security, the central government, the Ministry of Health, Well-being and Sports, they all got the same logo. There was one logo, there was to be one government, one state, and maybe in the future also one database. Purpose limitation. What does it actually consist of? You probably already had this. Data can only be collected for a specified, explicit, and legitimate purpose. And block 2, it shall not be further processed in a manner that is incompatible with those purposes. Together, purpose specification plus compatible use, you get purpose limitation. Okay, so Purpose limitation is not an absolute principle. Under Data Protection Directive, Directive 95/46, you could make an exception to the rule that was provided in Article 13 and that allowed to make an exception to the purpose limitation principle. However, in the Netherlands, we said, okay, that exception has to be in line with how you can make restrictions on fundamental rights. It has to be exception. It can only be in an individual case, and there has to be a good cause to make this exception. It cannot be permanent, it cannot be systematic, it can only be like this. And that was how it was in the Dutch legal framework, but that was also in other member states. Although some member states, admittedly, were already leaving that approach to the purpose limitation principle. So I always explain this through the case of Malone. Malone versus the UK. Malone was a sir who he bought stolen goods, and he had a telephone provider. Where is this going? You'll get it. There was a telephone provider, and the telephone provider of Mr. Malone had a metering device. And in this metering device, he stored the metadata. And the metadata was stored for a perfectly legitimate purpose, namely for billing and for fighting fraud. So that relationship between the telephone provider and Mr. Malone was a relationship that was governed by data protection. It's a transparent relationship, there's a normal purpose, an expected use of that data, nothing else. Fine. But then the police said, hey, you know what? I would like to have that data because we are accusing Mr. Malone of buying stolen goods, and we want to prosecute him. So then the question was, okay, can the police then just get that data? No. The European Court of Human Rights said, no, that's a new use of that data. It's an incompatible use. That is a breach of his right to privacy. It's for a criminal investigation, so it has to be provided by law, it has to be necessary in democratic society, and it's a legitimate aim. But what is essential about this case, it shows that there's a certain rule, then there's a specific case, someone is being suspected of a crime, and for that crime, you're allowed to make an exception to the purpose limitation principle. That is the important takeaway. Some people are falling asleep again. Okay. So it's an exception for a person who is suspected of a crime. Now, under the GDPR, there was a big change. Article 6.4 and Recital 50 says, when processing is based on union or member state law, which constitutes a necessary and proportionate measure in a democratic society to safeguard a legitimate aim, then the controller should be allowed to further process the personal data, irrespective of the compatibility of those purposes. So that is a whole new exception. That is basically saying, if it is provided for by law, and that law allows it, you can further process data. It says purpose limitation is not, it basically says the purpose limitation principle is not important anymore as long as that is provided for by law, which gives huge power to the EU legislator and to national legislators. So in the Netherlands, you can already see this happening. We have SIRI, the System Risk Indication. This is a system that the Platform for the Protection of Civil Rights, we challenged the Dutch government. We've taken them to court because within the System Risk Indication, you see you can start a collaboration where the tax service, social security services, municipalities can say, okay, all citizens of neighborhood X, this can be, let's say, 10,000 citizens, all their data will be sent to a collaborative unit. This is actually a foundation, a private foundation. It's called Stichting Inlichtingenbureau, like the Foundation Intelligence Desk, a bit Orwellian. And they combine all the data and they use a risk model to link the data, to make a connection to the data. And through that link, they produce hits. And if you're a hit, it can be that you end up in the register of risk notifications. For 2 years, you will not be told about this. Always when you have to start a court case, you have to go to the government to say, hey, can you stop doing that? And the government says, nah, we really can't. And then, then you can go on with the proceedings. So when we got to the government and we told them about our problem with this system, the response was this. But what is exactly the problem? We're only trying to discover what is deviating from the norm. Oh, yeah, that's a crime. And the thing that is very interesting that is happening there is that it's basically raster van doen. You're taking a big electronic net and you just try to find something. Now, the argument that is always being made is, this is efficient. This is efficient. We have to take care of an efficient government. But in the vision, in the view of a state, I'm not saying anything new here, human rights are hugely inefficient. That's the entire point, right? So if we're going to make that an argument, to put purpose limitation aside, we are disregarding its function as a limit on government powers. If government powers are exercised on a data-driven basis, then being able to consolidate your informational powers means that there is no limitation anymore on the use of government. That is a little bit charged, but if you think about it, it does make sense. Now, it's actually going a bit further now, because already in 2014, the Dutch government issued a report, and in that report they talked about the framework law data exchange partnerships. And there they said there were a lot of bottlenecks that actually prevented these partnerships from taking place. Bottlenecks, that's the new word for fundamental rights. There are bottlenecks to our policy. Yeah. In the proposal for the framework law data exchange partnerships, SIRI is peanuts compared to this. It's also called sometimes Super Siri by a reporter. And what it allows that you have the data of public authorities. They can send this data to a collaborative unit. And then private companies can also start sending their data. And this is all on the basis of a ministerial decree, which then the law provides the basis for the ministerial decree. And also within the data processing, which can be like a vaguely described purpose. Of course, it has to be specific, but we've studied how the Dutch government is practicing this idea of specificity, and it's not really specific, I can tell you that. So they're sending the data, and they can also use, this is also within the legislative proposal, they can start using AI to make risk assessments. So private companies, public authorities can find common ground where they think like the exchange of data is important here. They can start exchanging the data, and then that data can be processed, it can be analyzed, and then they can have an identification of risks. And you might become one of these risks. And the interesting thing is, it's not necessarily about whether you committed a crime or an administrative offense. It's also about the risk that you will do this. And you can end up in a register, risk notifications, exactly like in Siri, only this time there's no time limit. They try to create change with this, like change for money, like make it a very bad proposal where fundamental rights are not respected at all. So then you have something to negotiate from. The proposal openly states it wants to go from the public policy exception to the public policy rule. So the exception becomes the rule. Now this is interesting, because actually, what does the right to privacy in ECHR say? We always talk about the three requirements: provided for by law, necessary in democratic society, and for a legitimate aim. But there's another thing. It says except. Except. It has to be the exception. And what the GDPR is doing is creating a legal ground to turn the exception into the rule. And one thing that I think we really have to ask ourselves is this sidelining of the purpose limitation principle compatible with Article 8 of the European Convention of Human Rights, and more broader with our entire legal culture? This is a court case from 1901 in England, which shows how far it has gone. This is my last quote, and I'm done. The public interest in confidentiality as such is immensely increased when the information in question has been obtained by a public authority using compulsory powers. There are today numerous agencies of the state upon which, no doubt for good reason, Parliament has conferred the power compulsorily to obtain information and documents from the private citizen. If this information is not communicated to others but is known to and used by only the agency which is given the statutory powers to obtain it, no great harm is done. Let's rush before Arne starts singing. But if the information obtained by the police, the Inland Revenue, the social security offices, the health service and other agencies were to be gathered together in one file, the freedom of the individual would be gravely at risk. The dossier of private information is the badge of the totalitarian state. The court should be at least as astute to protect the public interest in freedom from abuse of powers as in protecting the public interest in the exercise of such powers.
Thank you, Tijmen. And I give voice to Judith.
Hello, thank you very much. Thank you very much for inviting me, and thanks also for doing quite a lot of the groundwork. That cuts my speech down by quite a bit. I've been asked to do two things. One of all, to not do a PowerPoint, because I was going to be the last person and there wouldn't be any time. We knew that already. The second one was to be short. I can promise the one, I can't do the other, I'm afraid. It would be a first. So I was particularly happy to be invited for this panel because in 2008 I actually wrote a paper called "Privacy is Dead, Get Over It," and I loved the title of this session, so it was really, really interesting to see that. And in that paper I was actually talking about the risk-free society and how our obsession with being basically without risk these days was starting to inform the way in which we view privacy. And I think this is one of the things that I would quite like to highlight in the context of the purpose limitation, because I agree with the previous speakers that what we are currently seeing is a massive change, not just in the law, but in the mindset of individuals, in the mindset of institutions and organizations. The first time that I really looked at that was for another paper that I wrote in 2013, and that was sort of sparked by me watching a press conference by Cecilia Malmström, who at the time was introducing the proposal for the European PNR directive. And that speech, that press conference, was very, very interesting because during that speech she said, I think no fewer than 7 times, things along the lines of, we are not collecting any new data, we are just using the information that has been collected for decades, the data is already there, we are not building new data systems, we're just finding new ways of using existing data systems, and so on and so on. And that struck me as really, really interesting because the statements were very clearly meant to reassure the public. We're not getting any more of your data, we're just reusing the old stuff. But for somebody like me, who is very privacy paranoid, and who obviously did have a sort of very intimate relationship with the data protection principles, and I said yesterday to my fellow speakers, purpose limitation is my number 2. I am very much in love with data minimization as well. So for me, this was something that was represented a very fundamental change in mindset, away from an idea that data is collected for this one specified purpose only, as Timon has just said, and towards an attitude where available data pools are basically seen as fair game for any number of future purposes. That basically, if the data is already there, we can actually do something with it. So this mindset highlights this increased appetite of law enforcement, and we've seen this with Teresa and Fanny, but I would actually go further, and I'm saying this is now a completely new way of looking at data. And public authorities, private authorities, they're all at it in this context. So although the PNR directive at the time was one of the initiatives, I actually then, kept my eyes open and looked at a few others, and maybe just go through a few that I've seen since then. So back then we were looking at the SWIFT agreement, the exchange of financial data with the US. We were looking at the opening up of the Eurodac database. We were looking actually at the 2006 Data Retention Directive, which was really nothing other than law enforcement grab of existing communications data. Of course, that directive is now defunct, and we will see if that kind of view of the CJEU that came out in that decision will sort of pervade if any of this ever comes to court. Back at home in the UK, we had this wonderful initiative that we called Care.Data, where the government wanted to centralize all the NHS patient data that was previously held by UK GPs in one centralized database, which they then wanted to give people access to for research purposes. That died a very swift death, largely because it became apparent that the first people they gave that data to wasn't actually the researchers, it was the insurance industry, and that was that. The Metropolitan Police, I understand, took something like 3 months from the introduction of the London Oyster card to the point where they requested geolocation data of individual Oyster card users for law enforcement purposes. So that was another public to private data grab. And more recently, there is a very, very personal example that we are currently seeing, because obviously I live in the UK as an EU migrant. And as such, post-Brexit, I'm going to have to apply for this thing called settled status. And when you do this at the moment, apparently at some stage there pops up a privacy notice which informs you that all the data that at that point in time is combined. So a lot of this data you have to provide, but quite a lot of the data you give them permission to draw from different databases. And that data is actually going to be, that they will be allowed to share this data afterwards with other public and private bodies for whatever unspecified purposes. And just in recently, we have now also found out that they are intending to establish a new centralized migrants database, which they call the Status Checking Project, and that is designed to share individuals' immigration status in real time with interested parties. And the interesting thing about this is that those interested parties do not just include public authorities, they include landlords, banks, employers. So this is something that is very clear examples of the way, you know, which way we are going. So all of these schemes, they go completely beyond our original concerns from the purpose limitation principle, which was function creep, which was basically just one authority or one organization having data for a specific purpose and then looking at that data and think, I wonder what else I could do with that. So we are now having this function creep cross-institutional, across different contexts, and data goes through a revolving door, really, between different public and private organizations, and the purpose limitation, I think, as you said, is sort of dying a death along the way. I think the problem that we have with that, and I'm going to completely leave out anything that I had originally put down with regard to the law, because you've beautifully done this already, but the interesting thing with regard to the changes that we saw between the directive and the regulation is that in between those two, and this is something you didn't mention, and this is why I feel entitled to do so. In 2013, the Article 29 Working Party actually published an opinion on the purpose limitation principle. And what I found interesting there was the timing, because of course that was after the proposal for the GDPR was published, but before it was adopted. So they basically went to all the trouble of giving us a really, really, specific interpretation of the purpose limitation principle under the DPD, which I could really only read as a wish list as to what they thought the GDPR would be doing. And what the GDPR did was, in fact, no such thing. So the GDPR is very much a moving away from quite a lot of the principles that the Article Working Party highlighted. Among other things, the principle that you now no longer need a legal ground, a new legal ground for the data that is found to be compatible, and of course this real watering down of sort of member states now writing their own authorizations by saying that, okay, so this is compatible by law, even if it isn't by sort of normal standards, we are creating and decreeing that this is compatible processing. So to a certain extent, the question here is whether we have given carte blanche to member states to write their own laws in this area. And the reason why this, I think, for us is such an important point to talk about at this point in time is because we are now at a stage with technological development, with data science, where we're actually starting to go back to basics a little bit. We are starting to talk a little bit again about values. We are starting to look at why we have some of these principles in the law in the first place. What is the history of that? And without wanting to go into any kind of detail, I think one of the things we can agree on potentially is that the purpose limitation was very much designed to protect individual autonomy in the context, what the German Constitutional Court used to call the informational self-determination idea, but that was not an individualized right as such, and that is something that the Constitutional Court also made clear all the way back in the 80s, when they very much made it clear that they created that right, not just to protect individuals, but to protect the societal importance, the societal relevance of that autonomy, by saying that individuals that always feel observed will ultimately no longer exercise their own democratic rights. And I think this is one of the things that we now basically have to consider again. What is, of course, interesting is that all of this happened around about the time that we were starting to talk about this idea of big data and what I call this all-you-can-eat data, really, because this is pretty much what we're looking at. And to summarize what the previous papers have said, I think one of the things that we are currently being sold is it is presented to us as a non-contestable conviction that there are certain reasons why we have to let go of the purpose limitation principle. And I've got 4 of those reasons. One of them is a security imperative. That's a very easy one. One of them is the economic imperative. Data collection is necessary. It's the AdTech reason, basically. It's necessary to keep certain business models afloat. One of them is what I generally call the share because you care. So this is the we can cure cancer thing, if you know, the data philanthropy sort of idea. And one of them is, of course, the I want it, the precious kind of thing. So we are all doing it for convenience reasons. And if we don't do that, then we have real lacks of convenience. The question here, therefore, is how do we deal with this? And this is my last slide. Anna will be very happy with that. How do we deal with this? I think the way I've been thinking about this for a very long time is that we have to return to an evidence and values-based root and branch review of data processing practices. We cannot just always accept that just because there is an imperative, that imperative will automatically win out. We cannot automatically prioritize certain interests, even if they are public interests, over individual interests, because those individual interests often have a public interest component. And that is something that we really have to start remembering again. We must take, therefore, a much less binary and a much more holistic view of competing interests that does represent them, not as direct conflicts, so the privacy versus security, privacy versus convenience, but we have to see them as some sort of an equilibrium. There's always more than two interests at stake, and they always have different kind of weights, and I think if we see them more as something that needs to be kept in balance with regard to all sorts of different and much more complex systems of interest, then we cannot just say, well, this one's obviously more important and the other one therefore has to give way. We have to revisit, and this brings me back to the 2008 paper I wrote, I think we have to revisit our own risk assessment processes, and we have to question our own increasing risk averseness, because sometimes maybe there are things that are more important than that. And we must certainly question both the technological and the data determinism that we have sort of grown into in the last decade or so, where we have to say just because we can doesn't mean we should be doing it. And I'm quite hopeful, actually, because this is a discussion we now have in the area of AI, of machine learning, and all of this sorts of stuff. So we seem to be touching on this one. Whether it's going to get us anywhere is anyone's business. Anyone's question. Thank you.
Thank you, Judith. Thank you, Judith. I would like to also thank all the speakers for making such a strong and clear presentations and highlighting different aspects of what I think Judith nicely called this shift in the mindset of the institutions toward more data, more interoperability between databases. And I think it's you all made it very clear how this complex issue actually is a problem and how it arises. So thank you for that. Actually, before opening the floor and getting questions from the audience, I have one question I would like to ask to our panelists. So what it seems to me, what Judith called this shift in the mindset of institutions towards more interoperability, more data, it seems like a very important political choice. I was wondering whether you see a lot of discussion on the societal level, whether there's a lot of political engagement, whether it is presented as a political choice, in fact. I was wondering if you maybe could reflect on that and perhaps also relate to presentations of other panelists. Perhaps it's the most question to Judith, who was the more...
Yeah, I think it is definitely is a political choice, because it also is also a choice that represents an exercise of power. And from that perspective, of course, it is a political choice, because the ones who make that choice will massively gain in power. The interesting thing that I find is the way in which it is sold to us. So we are basically being tricked into this in a very large part. We are almost raised to be risk averse, and then that risk aversity is sold back to us in terms of protector. And one of the things I'm actually, this is completely unrelated, but what I'm working at the moment is looking at how children are now raised to be particularly risk averse and wanting to be protected all the time. And that is something I think that we're seeing very much, because a child that is raised with constantly needing to have somebody look out for them will very easily become an adult that constantly needs somebody to look out for them. And I think this is a very interesting dynamic that we're now seeing, that there is an idea that represents a certain exercise in power that is being sold to society as a good thing, when in fact it has massive, downsides for autonomy and other kind of rights and values that we're not necessarily reminded about. So I think, we probably need to make sure that the idea that this is a political choice and that there are other choices available, but that they also have downsides, but that we need to be adult about this and discuss them. I think that is a discussion we need to have.
Mm-hmm. Thank you, Judith. Anyone from the panel would like to reflect on that?
I also think it's very much a political choice. The idea to create interoperability of EU databases exists already since a long time ago, but back then the costs were first too high, and then also the threat of the internal security of the Union was not perceived as very pressing. And that changed then in 2016 or 15-16 with the so-called migration crisis and the terrorist attacks in Paris and Brussels. And then suddenly there were proposals to establish new databases and to revise the old databases. And then on top of that came now in December 2017 this proposal for interoperability of databases. And now the whole system became so complex that it is very difficult to understand it, because already one needs to know all these underlying databases and then the interoperability components. And the thing is that it is said in the proposals, yes, EU citizens will not be included in these databases, and it is for security purposes, and we need this. And yes, if it works, there's also some good things about this interoperability. I mean, concerning data minimization, but the thing is that databases that were established for specific purposes, for a specific reason, at specific times, are now being all merged together in some gigantic interoperable system that no one understands anymore, and I don't know if that is an agenda.
Okay, thank you.
Just to add there, of course, I think it's a political choice, but from what strikes me is more the lack of debate. No? If we make this choice, and that was a bit the message of my presentation, if we make this choice, we should at least assess the impact it has on how we regulate, and this is not happening.
Mm-hmm. I think so too, and I also think that's why it was so great that you made this clear presentation and how those technologies are kind of watering down the big issues that we have when we don't actually hold debate about. Okay, I will maybe gather now some questions for the audience. Is gentleman? Okay, we have a couple of questions. Gentleman there in the middle was first. Maybe you can step to the microphone, or. Yeah.
Michael Eloy, University of Zurich. I'd like to know what will be the exceptions in which you will actually favor the unification of the data resources collected with different purposes, considering, of course, also areas such as healthcare, research, in particular research on health, also as a matter, of course, of of efficiency, including in realms like healthcare, in which more efficiency can mean you can cure more people, and so on and so on. So what will be for you the justification, if ever, for this kind of practices that you criticize?
And who is the question for? It's for all the panelists, or? Oh, okay. Okay, great. Maybe we'll get another question, and then we will answer them in a bunch. Gentleman here in the back was first, I think. Here, yeah. Sorry.
Okay. Hello, I'm Roger Salonge, PhD student, University of Turin. Okay. I get the feeling this whole erosion of the purpose limitation principle is quite interesting, because I was wondering, how do we balance that then with the right to be forgotten, for example? Because I get the feeling sometimes specific purpose could also mean forever, especially in terms of convicts, like past convicts. I know, for example, in law, in criminal law, it's always necessary. Sometimes being a first offender, second offender, being a second offender can be an aggravating circumstance. So if I leave prison, for example, that data of me being a convict, is it being processed for a specific purpose, and that purpose could be defined as getting me more time in prison, maybe if I have a second offense, or maybe balancing it with the right to be forgotten. Like, do I have a right to have data about me deleted? That's basically what I'm trying to, my doubts about it.
Thank you. And I think there's another question, gentleman here in the front. Thank you.
Thank you very much for your presentations, which were basically or mainly on data processing by authorities. When you look at the overall concept of purpose limitation, I was wondering if you, or I was surprised that you did not mention Article 5, Paragraph 1, Littera B of the GDPR, which is dealing with the processing for scientific purposes, for statistical purposes, and for archive purposes. In my interpretation, this at least for those purposes, the principle of purpose limitation is not there anymore, because this provision says that further processing has to be seen as compatible. So I wonder if you would interpret this provision in the same way.
Okay, one more question here.
One quick question. Mark King, do you think that it is in fact power or weakness which is the reason for people doing things like the Open Data Initiative, trying to claim that, oh, we'll have innovative, new and exciting uses for this data without really knowing where it's going, but in hope rather than expectation?
Okay, perhaps we will now answer the questions. You have enough, I guess.
I think I'd like to take the first one and your one together, because I think they're quite a good way. So I think one of the things I would like to say in this context is that I personally am not one of those people who say we must never use data for other purposes. I actually think the European data protection framework is very, very good, specifically because it isn't binary. We are not discussing data protection as an absolute control right of the individual, nor are we discussing it as something that is free data, free for anybody to access. The European Data Protection Framework makes a very clear balancing act between a level of control that is basically represented in the consent principle, combined with a number of recognized public interest purposes for which data can be processed even if you do not consent. And I do actually fully subscribe to that model. I think what the criticism about further compatible use or further incompatible use was about was not so much about the individual cases, but the process that is being used. And that process at the moment is very difficult, and health data is actually a very, very good example for this. So this care.data scheme that I mentioned that the UK was doing, that would actually arguably have been unlawful under the DPD, it no longer is unlawful or would be unlawful under the GDPR. So that is a really big shift in what the UK government could be doing. However, the problem that we're facing here is that I think you are perfectly right that we actually went far too far in the GDPR. I mean, there is, of course, Article 89 with the appropriate safeguards and stuff like that, but seeing as none of us at the moment know what those are, and I already know what my government is currently making of them, and it ain't pretty. This is something where we really have to see. And I think one of the discussions that I had with regard to care.data, coming back to you again at the time, was that I talked to a lot of my colleagues in Edinburgh because we have a medical law team, and they do a lot of work for Wellcome research and all of that sort of stuff. So you can imagine we have quite differing points of view about this sort of thing. And for me, it was about circles of trust. So what I want is to have this conversation about what circle of trust I am comfortable with as an individual, and what kind of circles of trust we could, as a society, arguably, use as justifiable. And for me, this was like, I trust my GP. I would probably be okay with that data being made available to university researchers. I am already a little bit more when it goes over to pharmaceutical industry. And of course, when it came to the insurance industry, I was like, no way, okay? So I think what we have to have is these kinds of considerations. We have to have a marketplace where these things are being discussed. And then maybe just to mop up the power thing as well, I think this is the problem, because the weakness and the power comes from the fact that we are not the ones as individuals or even as researchers to determine the debate. We are not creating the opportunity for the debate. And that means that very, very often the debate doesn't take place. And I think this is partly where the power imbalance comes from. And that is definitely something that has changed, because we are no longer even asking to have the debate in many cases. And I think that is a problem. I'm not sure if that answers your question.
Yeah, I'm not sure which question was addressed to me, but I will respond to the first question about the efficiency, and maybe also about the scientific research a bit. Yeah, who determines what efficiency is? So what are the benchmarks? Usually efficiency only addresses all things that can be measured by governments and corporations. Now, if you combine these two together and make that the holy value, you have a fascist state. Is that so? That is pretty problematic for me with respect to saying, okay, what about the efficiency? If you say, I really like the metaphor about risk-averse children. What is the purpose of civil society? What is the purpose of our society? We want to have a society in which we have critical individuals that can participate, that can maintain a tolerant and diverse society, because a diverse society is also a society which can actually resist outside pressures that go into populism or things like that. For that we need autonomous, free-thinking people. Ruth Gaveston has excellently commented on this, saying that privacy is fundamental for a democratic society because it requires autonomous decision-making, autonomous citizens. It is a little bit, but in that order. Funnily enough, I visited one of these panels that was about like big data in learning. And there you also hear the efficiency argument. We have budgetary shortages, so we should actually involve more technology on schools to actually to alleviate the workload of teachers and have less teachers and more technology getting in place to teach our children. Now, Priscilla Reagan was in that panel, and she's very interesting because she actually writes about the societal value of privacy. She also comments on John Dewey that says civil rights are at the heart of society. It's not just something that you can balance out with something else. It's on the heart of society because it actually guarantees a critical citizenry, which is critical for our existence, for our survival as a species, I would say. Looking at the experience that we have on this continent, I think that is something I can just easily say. The point is, if you take that efficiency argument and you would look at the schools, and at some point our children are being only taught by technology. To charge, they would become the new Facebook foot soldiers. Just being taught within, just being taught to think within those domains. So, yeah, it basically boils down to, I think efficiency, I think there are values. I think efficiency is also in values that we cannot measure. So I hope that efficiently addresses that question. And then about research, what I find interesting and problematic is that when does something qualify as research? I don't know whether that is commented on in the GDPR, but for example, in the Netherlands, we had a project called FinPro, where the municipality, together with some companies and the public prosecutor, started putting data together. And they put the data together. Yeah, I will finish soon. they put that data together at a private little private company that was actually run by a professor in strategic innovation of the Nijrode University. This university for, you know, like a very expensive university. And she said, "Oh, bring all the data together and we will do scientific research. We will perform scientific research on the data." And then there were very interesting results, and the results were actually shared on the ministries, but then destroyed. The only interesting thing was, it was in Rotterdam, and in Rotterdam, for those who know Rotterdam, it was applauded in our Financial Times, but it was in the south of Rotterdam, which is the area with the weak people, economic weaker people, not schooled in law. If you would do the same thing in Amsterdam South, where all the rich people live in the Netherlands, or at least a lot of them, I'm pretty sure that that whole idea, that conviction, that scientific research would have been challenged in court.
Let's move to, thanks.
Sorry.
I will just add one thing about the efficiency argument. I think when, efficiency is already bring forward, but if it really goes against our values or civil values, I think what we need to do is just to be a bit more creative sometimes. Sometimes we use the efficiency argument because it's the easy way to go, but I'm thinking, for instance, to all the research in privacy by design, where people are actually developing new tools, new way to get to achieve the same goals with protecting privacy. So sometimes it just requires a bit more of creativity. So yeah, I think we should not hide behind the argument of efficiency.
I don't know how much I have to say to these questions, but in these databases, you don't have a right to be forgotten, but there are retention periods, and after that, the data will be deleted if it's not needed. Whether these retention periods are proportionate is another question. The data in these databases will also be used for statistical purposes, but only in an anonymized form. And about the efficiency question, yes, this kind of system could also be seen as very efficient, where data is only retained to a certain extent. But what we're seeing now is that more and more data or types of data are being added to the existing databases and to the databases that are being established. And whether this is really possible to make all this interoperable and then find incorrect data, as is claimed in the proposal, is yet another question, because already now the systems include incorrect data, and whether that will end up in being a lot of wrong matches, and whether they can all be corrected in the end is questionable.
Thank you so much. I think we'll finish here because we have maybe 1 minute left, so I'm not sure if there's one last burning question, but I guess we can just close here. Thank you. Let's applaud our speakers.
I want to also thank all of you for staying here with us until so late, and thank the panel once again for being so perfectly in time. And as a gesture, I will hand them some Belgium chocolates, and I hope you enjoy the rest of your stay here in Brussels. Thank you.